The right to an abortion in South Carolina is once again being deliberated by the state's highest court. Republicans are seeking to reinstate a ban that was overturned earlier this year. Notably, this case is being presented before the only state Supreme Court in the country composed entirely of men. Welcome to Slant News. If you want to support, you can subscribe to our channel. This will be the second time lawyers for the state and abortion providers present their arguments to the state Supreme Court since the U.S. Supreme Court invalidated federal protections last summer. In January, a 3-2 majority struck down a similar law that prohibited abortion once cardiac activity was detected, typically around 6 weeks, when many individuals are unaware of their pregnancy. Recently, Republican Governor Henry McMaster signed a comparable ban into law, which also hinges on the detection of cardiac activity. However, the implementation of this restriction has been temporarily suspended as the legal challenge unfolds. Presently, abortion remains legal in South Carolina up to 22 weeks, even in this conservative state. The dynamics of the case have shifted due to changes in the court's composition. Justice K. Hearn, the author of the lead opinion in the January ruling and the court's sole woman, has since retired after reaching the mandatory retirement age. The arguments presented on Tuesday will be heard by an all-male bench, including newly sworn Justice Gary Hill. This case will test the durability of the January ruling. State lawyers must meet a higher threshold, as the state Supreme Court has instructed them to argue why the previous ruling should be overturned. In an unusual move, all 5 justices wrote their own legal justifications for the January decision. State lawyers contend that this approach has left the ruling without a solid precedent. Lawyers representing Planned Parenthood South Atlantic argue that there is no substantial distinction between the two laws, as both restrict abortions at a similar point in pregnancy. They point to the collective opinions of the 3 justices in the majority, which established that a ban at approximately 6 weeks violated the state constitution's right to privacy, as outlined in a legal brief. The new law closely resembles the ban from 2021, which was invalidated in January. However, Republican lawmakers have made adjustments to the law in the hopes of swaying the vote of one justice who narrowly joined the majority in the previous decision. In their legal briefs, the state contends that the new law directly addresses Justice John Few concerns that the General Assembly did not adequately consider whether a 6-week ban allows patients sufficient time to realize they are pregnant. The lawmakers assert that the new law takes into account the patient's opportunity for a meaningful decision-making process and the necessary arrangements. They reference data from the U.S. Centers for Disease Control and Prevention, indicating that about 45% of abortions nationwide in 2020 occurred within 6 weeks of pregnancy, and nearly 81% occurred within 9 weeks. Planned Parenthood South Atlantic's lawyers argue in their legal brief that the Republican-led General Assembly mistakenly believes that substituting certain words can rectify the substantive unconstitutionality of the new law.